So welcome, Kekek, and thank you so much for being with us today.
Well, bonjour, Kekek Kinago, Anasing Women, Vision, Rode, Mekanakuyan, and Wimpa, Dash, Nimiquino, Nimiquitran, Maya, Mano, Boom, Tekagi, and so my name is Kekek, and we're going to talk a little bit about tribal sovereignty and citizenship, thinking about 100 years of the Indian Citizenship Act and how that plays out and how that's been affected by law and policy, specifically with regard to Indian. So, Vine which is interesting, a lot of my students now don't know who Vine was, so like he's often called like the godfather of Indian law. But he explained that the idea of sovereignty was an ancient idea because a lot of times, you know, people have asked the question as a typical European principle, should we apply that to Indian country, should we apply that to tribes, or should we use some different interpretation of the concept? And he says it is inherently tribal. We had the ideas of sovereignty specifically connecting to our identity and our creation stories and our connection to place. So our connection to place plus our identity really represents the heart of tribal sovereignty as it goes forward. So important thing to think about as you begin to think about how tribes are implementing their sovereign principles and their governance. And what's also important is that the practice was exercised externally and internally, both within the group, the kinship network, the band itself, the tribe, and then externally with other tribes, other sovereigns, Europeans. So that sovereign authority was both internal and external. So this becomes important when we begin to see federal Indian policy later and how that's affected. The other interesting aspect is that tribes are pre-constitutional. Our sovereignty comes from creation, therefore it existed before the United States was formed, and so some also call it extra-constitutional, so you'll see those terms, and it's about that pre-existing relationship. And a lot of people confuse the idea of sovereignty coming from the Constitution. It does not. Tribal sovereignty exists outside of the framework of the U.S. Constitution. So when we begin to see the origins of federal Indian law, so one of the first principles is the Royal Proclamation of 1763, which essentially set the boundary line between like the U.S. colonies, or at first they were the British colonies, and Indian country. So everything west of the Appalachians was Indian country. Indian law applied, and the principle that they were separate governments, separate entities. Tribal law existed within the realm of Indian country, and even before, but it was this policy of separatism. So with the Northwest Ordinance, they passed the ability to open up those additional lands. So as you see, the United States begin to expand, but those principles of separatism continue to exist, and the idea that, you know, state rights doesn't apply within Indian country. Also, when we begin to see some of the Indian references, we start with the Declaration of Independence. So you see the phrase, the merciless Indian savages. And so this idea of savagery, conquest, you know, this language becomes important when we think about how laws and policy is created. And so we'll see this principle kind of continue throughout time as well. So also we had Johnson v. McIntosh. So we think about 100 years since the Indian Civil Rights Act. It's been 200 years since Johnson. essentially that define what Aboriginal title is, and really the idea was that tribal lands could either be purchased, could be done or acquired through conquest, or if the tribe abandoned it. It also said that their title included basically all aspects of possessing their territories, using it, and the power to exclude, which is part of the police power. And their ability to transfer was potentially limited, not because the tribe didn't have the authority, but the doctrine of discovery created this preemptive right of purchase among European sovereigns. So it was actually US law with regard to other Europeans that limited that title. So this will become important too. So the notion of conquest begins to show itself in the law, even though we know all of North America was essentially purchased pursuant to treaties. So when we see the Constitution, some of the Indian references, so Article 1 talks about Indians not being taxed and being excluded, so they were left outside the Constitution and its principles. 14th Amendment, again, has the Indians not taxed provision. Then we get the treaty clause. So Article 2 says that president, so that defines presidential powers. The president has the power, with the advice and consent of the Senate, to make treaties. And then within the same treaty clause is Article 6, which is the supremacy clause, which says treaties are the supreme law of the land. So that becomes important when we talk about treaty responsibilities. And then we get the Indian Commerce Clause. So, Commerce Clause, Article 1, Section 8, Clause 1, Congress has the right and the power to regulate commerce with foreign nations, states, tribes. So this becomes interpreted interesting. So a lot of times you hear the Interstate Commerce Clause talking about the states. The Indian Commerce Clause is the provision talking about tribes. And the idea was, well, what are these tribes? We know they're sovereign, but they're separate from foreign because they listed foreign nation, they listed states and tribes separately. So there's something else. What are they? So that brings us to Cherokee Nation, 1831, where they talked about tribes being in a state of pupillage, right? And so they were like, oh, they look to our government for protection, which is interesting because a lot of the protection provisions in the treaties were actually put there by the United States saying, hey, enter this treaty with us, have exclusivity with us, like don't go trading with the British anymore, leave the Spanish alone, don't have agreements with France, we'll protect you and we'll have exclusivity and trade with you. And so it was actually the United States that perpetuated this principle, not the tribes itself, but then it was used as a diminishment again later to be like, oh, they needed our protection, they needed our help, they're in the state of pupillage, less than. So when we think of the Indian Commerce Clause, they created this idea that tribes are domestic dependent nations. They're still nations, sovereign, but they're domestic because they're within the United States or the territory of the United States. But you get this idea of dependency that will continue to show itself. So that brings us to Worcester, which created the guardian-ward relationship. So they expanded on the idea of domestic dependent nation to say it's like a guardian to the ward as the source of Indian rights and Indian power. So you see the quote, a weak state in order to provide for its safety may place itself under the protection of a more powerful nation. So this comes on, right after the war, 1812, of which tribes were doing pretty well, specifically the tribes that sided with the British, right? So like they didn't actually lose the war, cede the war. So if you think of in the Great Lakes region, they took over Fort Pitt at Pittsburgh, they took over Buffalo at Niagara, they took over Fort Stanwix by Detroit, right? They were actually acquiring territory. So the idea that, hey, these tribes are weaker, that wasn't actually what was happening at the time. So this guardian-ward relationship and the duty of protection, though, creates what we understand as the trust responsibility. So U.S. has a duty to protect tribes from foreign nations, to protect tribes from the states from interfering or, again, entering their territory, and for those that are trying to take their land. So that creates what we understand as plenary power. So plenary power is the authority for the federal government to exercise power with regard to Indians. So two cases that really set out the frameworks for what the limits of Congress's plenary power is, Kekek and Lone Wolf. And really, they, again, utilize this idea of dependency and diminished capacity to basically say the United States has this duty to do whatever they want with regard to Indian affairs. So Cohen, who, interesting, he was the Solicitor General, and he wrote the Handbook of Federal Indian Law, still used today, like the current version, but he quotes that the power of Indian affairs comes from the idea of conquest, right? So again, you see this idea of conquest rise its hand again, even as late as the 60s, as this artificial articulation of where that power comes from. So originally, the idea of plenary power came from that guardian-ward relationship, but lately the court has said no, it actually stems from the Treaty Clause and the Indian Commerce Clause. So that's why it was important when we put those provisions up there. And originally, if we look at Kekek and Lone Wolf, the plenary authority was absolute. Like there was no subject matter restrictions, but everybody, a lot of scholars argued against that. And they say you actually need a commerce hook or a commerce clause hook. So there has to be some connection between either the treaty clause or other clauses in the Constitution to give the United States the authority to exercise management Indian affairs. So the argument, it was not absolute but limited, and actually was supposed to perpetuate those trust duties and further tribal sovereignty. So this creates what we understand as implicit divestiture, which the idea was tribal sovereign authority was limited. So again, we said tribal sovereign authorities internally and externally. And the court has said, well, this right externally towards others is diminished because of this idea of conquest. And we know it's actually it's false. And it was created what we call federal common law, because there's nothing actually, there's no act that did it, Congress never said it, the court created it. In U.S. v. Wheeler, that was then took hold. So we say they planted the seeds in Wheeler, then you had Marion, and by Oliphant, which said that tribes no longer have criminal jurisdiction over non-members, was where like the seeds blossom and they're like, oh, that power, that sovereign authority was diminished. So again, it's important to understand these principles as we move forward, to know that, hey, you know, where did that power come from? It was actually not exercised, and we should stop utilizing that language of diminishment. So again, you get I always call it the two-sided coin, right? You get trust responsibility on one side, and you get plenary power on the other. And so typically the trust responsibility is used to further tribal sovereignty. Plenary power has been used to diminish tribal sovereignty. So with understanding what the trust obligations are, so the United States entered into 400 plus treaties with tribes, and plus hundreds of agreements after 1871, which were fairly recognized as treaties as well. And from those treaties are these responsibilities and obligations of the United States. So that's where we get this idea of a special relationship between tribes and the federal government and the obligations, right? So you also get the idea of utmost good faith, that they're supposed to keep their end of the bargain of those treaty principles. So we also understand that as a responsibility supporting tribal self-government, economic prosperity, and those treaty guarantees, right? So it's supposed to uphold and further tribal sovereignty. So now we understand that as duties, duty to provide services. So you see Indian Health Service, housing, so NAHASDA, the Native American Housing Self-Determination Act, the Self-Governance Act, the ability to protect sovereign, and the duty to protect tribal resources. You also get the idea of consultation, the duty to consult with tribes, and that's actually shifting more from consultation to consent, to get tribal consent with regard to the use of their territories or their resources. So just this last summer in Brackeen, so Brackeen looked on the constitutionality of the Indian Child Welfare Act, and the court really dived into what this plenary power is, right? What's the scope of it? So here the court said, plenary power is not absolute. It's not free-floating. It's not this unlimited power that Lone Wolf and Kegema said it was. It's limited. It has to be connected to the Constitution, and therefore it's limited to those clauses. And they said, really, it's the Indian Commerce Clause, the Treaty Clause, and the trust relationship. Then you get the Supremacy Clause as treaties, the supreme law of the land, and there's some inherent principles of sovereignty that guide the ability for Congress to act in Indian affairs. So it is limited, and it's limited to those responsibilities of furthering tribal self-governance, tribal self-determination. They also said the Indian Commerce Clause isn't about like just commerce or trade or economic development. It's all aspects of Indian affairs. It's pretty broad, but it's not absolute. It's not unlimited. So again, it's not unbounded. It has to be connected with those acts. So here they're like, well, it's broad, but it's not unlimited, right? So they said specifically criminal law, domestic violence, property tax, trade, all aspects that are within the guise of Congress to act with regard to Indian affairs. So we'll see how that played out with the idea of citizenship. So again, we started with the Royal Proclamation, and so in the 1820s through the 1860s was the removal period, where they wanted to remove tribes west of the Mississippi River. And so we get a number of tribes. So here you see the Wyandotte removal. Same happened with the Potawatomi, the Delaware, obviously Cherokee, Choctaw, Chickasaw nations in the South. And so part of removal was the idea that, hey, we're going to send you to Oklahoma. Eventually it was So here you see Kansas City. A lot of tribes went to Kansas City, Kansas, before they moved into Oklahoma. And they said, if you want to stay in your territory, you can, and you can gain citizenship if you stay there, but we're not going to recognize you as a tribe anymore. So they had these termination provisions for those that stayed. The tribe would be terminated and the individual Indians would become citizens. So, also was the requirement that those that were given citizenship would have to really try to become civilized, right? So they would be given individual land allotments and they were supposed to begin to live this civilized life.
I have a question.
Yeah?
How many took them up on it? Do you have numbers?
From the early treaties?
Yeah.
We have numbers later, but there was a number of tribes, so like Eastern Band of Cherokee stayed, they're now re-recognized. Most of your Michigan Potawatomis, so Kekek and Potawatomi, they're all re-recognized. So you get a number of tribes now that are in the East that had stayed, gained federal recognition later, and so it wasn't really what panned out, and we'll see why that Citizenship Act then in late 1800s wasn't what it was, they put it out to be. We have U.S. v. Rogers, 1846. So this is the first time the court decides who's an Indian. And so when we think about a citizen, how we apply citizenship becomes important. So here, you have a non-member. So again, we talked about originally, any individual that went into Indian country was subject to their laws, right? So we had two non-members who were married into the Cherokee Nation, right? So they were both non-Indian men, married, they got in a bar fight, one killed the other. They were going to be subject to murder, and they're like, hey, I'm a tribal citizen. You can't convict me in the United States, I'm subject to tribal law. Court said, no, you're a white guy. You have to be of the Indian race to be considered an Indian. So first time race is defined in the idea of Indianness. So the idea is you have to be of Indian blood and have some type of relationship with the community, right? So maintaining relations becomes the test on Indianness. So this was expounded in 1856 with the Attorney General Cushing. So he said being a member of the Indian race was someone who is incapacitated and disabled. So they took the guardian ward status to incapacity, right? And they said by the mixture of blood, right, the more white blood you get, your capacity decreases, right? So the idea was you could dilute your tainted, darker blood by being an Indian if you acquired more white blood. So again, this then goes to the idea of plenary power, where they say, hey, there's this reformatory control, right? So we know all the assimilation policies that were implemented, was this including boarding schools, prohibition on speaking languages, prohibition on culture, was a reformatory practice, right? So they said plenary power, this ability to have control, includes these abilities for the agents to make decisions with regard to this incapacitated people. They also talked about, hey, they're getting all these monies for the sale of their territories. Once they're open for homesteading and they're purchased, they put all these monies in tribal accounts. And so they set up this idea of how they're going to pay them, reserve this money, but then it's up to the Indian agent to decide how that money's spent, not to the band. And you'll see how that plays out too. So that also became part of the General Allotment Act. So this is 1876, so 10 years later, we know General Allotment Act opened up most of Indian country for the loss of tribal lands occurred as part of allotment. So you see in 1871, Mr. McKay, who was a mixed blood Chinook, so this is in Oregon, he went to go vote, and he said, I left my tribe, I've been living like a white man for many years, I'm living in town. And the court said, no, because you still had Indian blood, that you're still subject to the jurisdiction of the United States. Therefore, the 14th Amendment doesn't apply to you. Because that thing says those Indians not taxed are excluded, right? So that comes back to say, even though you're living as those principles of citizenship said, separate from your tribe, your traditions, but they still said you're not protected by the 14th Amendment or the idea of citizenship anyway. Then we have Elk v. Wilkins, 1884. So he was Omaha. He left his tribe in Nebraska, moved to the city of Omaha, again became living like a white man. And he went to the courthouse in 1880 to go vote. And they said, no, cannot even enter the place. So he sued. So he said, 14th Amendment made him a citizen, 15th Amendment gave him the right to vote. Supreme Court said, 14th Amendment does not apply to Indians. And they said that Section 2 of the 14th Amendment specifically included Indians not taxed, and therefore, because they were not taxed, they were not citizens, and therefore, 15th Amendment doesn't apply. So they also said, this idea, they added some great language, right? That it's up to Congress to decide when the state of pupillage is released. Right? So when this idea of being incapacitated and you're able to take up the responsibilities of citizenship, that Congress has to decide. So again, if you think that's within their authority, plenary power or not. And it says each individual Indian can't make that decision, only Congress can. So interesting, that was U.S. Supreme Court. So then with the General Allotment Act in 1887, again, just like the earlier treaties, they said everyone who takes an allotment is entitled to citizenship. So the idea was citizenship is granted in exchange for millions of acres of land. So with that was the 25-year trust period, right? So if anybody hears about trust property, trust responsibility. Originally, it was 25 years. Oh, there it moved. Went the wrong way. So that 25 years was supposed to allow for individuals to become civilized in that process so they could take on their own affairs. Because they said allottees at the time were not competent because they were, again, disabled, and they weren't able to manage their own land or own affairs in the meantime. And they couldn't assume, therefore, the responsibilities of citizenship. So here's your numbers. So 1890, 5,300 allottees became citizens. 1900, 53,000. So you see that increase. 1901, 100,000 Indians in Oklahoma or Indian Territory were awarded citizenship through allotment. And in return, they lost 90 million acres of land. And then 154,000 Indians have become citizens. So this is before you even get the Indian Citizenship Act.
At that point, were Indian people allowed to vote?
No. So we'll see that. So even after that, they're still not allowed to vote, because they're still Indian.
What, were they taxed? You know, like the guy behaving like a white guy, was he taxed?
He was taxed,
Okay.
right? You go live, like, once you leave the reservation, we all pay taxes on everything,
Yeah.
right? So he was still taxed, he was. So here they say about half the Indian population are granted citizenship by General Allotment Act. So then you get the Clapp amendments. So you have the General Allotment Act, then you get the Burke Act, and then you get the Clapp amendments. So you get amendments to the General Allotment Act and how it's implemented in different parts of the country, how it extends to the children of those that got the original allotments. In the amendment, they said any mixed blood automatically became competent. Because again, you have this mixture of blood, therefore you're competent enough to sell your land. And it was, white blood was the source of the competence. So, you see the report from the Commissioner of Indian Affairs, he's like, this new policy means a new dawn in the era of Indian administration. They will no longer be treated as half ward and half citizen. The idea was they're going to get these full privileges of participating in the nation. But we know that did not necessarily happen. So the same year, 1917.
What were the citizenship advantages that they were allowed?
None. Because they were still Indians, right? So here you get the perfect example, which was basically utilized all over. So they said, hey, so this is Minnesota. They said anybody who's from the reservation are not subject to taxes, therefore they're not subject to citizenship. So even though if they got it through allotment, they got it through a treaty provision. So even at the time, a lot of the Minnesota treaties actually had allotment provisions that were built in separate from the Allotment Act that also had citizenship provisions. You also had the half-breed script and the ability to take land anywhere. So you get actually a lot of Montana lands with both Rocky Boy and Little Shell and Turtle Mountain as part of those Chippewa scripts throughout, because you could take them anywhere in your territory. And even with those, they still said, well, you still can't vote, right? Because you're still not able to participate. You're still not competent. Even though you're competent enough to sell your land, you're not competent enough to participate in the United States government. So Montana did the same thing in 1911. Anybody living on an Indian or military reservation who had not otherwise acquired residency in Montana could not be regarded as a citizen or a resident for citizenship abilities. So then in 1919, Congress granted citizenship to anybody who fought in World War I and were honorably discharged. So this is the third time they're like, hey, you can get citizenship again. Right? Then in 1924, we get the Citizenship Act where they're like, all Indians are citizens. Fourth time. So even though they were naturalized, they still didn't get the constitutional rights. Right? So you see this idea of the Indian getting denied voting rights at the polls. So then you have the Merriam Report, the problem of Indian administration, which really was precursor to the Indian Reorganization Act. And basically they're talking, part of the report talked about how Indians who were citizens were not given the rights and freedoms that everybody else had acquired. So you see a little excerpt from the actual report. So Indians were not allowed to vote in city, county, state, or federal elections. They weren't allowed to testify in court or sue. They couldn't bring a case. That's why when we started with Cherokee Nation sued, say, hey, Georgia's infringing on our territories. They're like, hey, you can't bring a case because you're an Indian. That's why in Worcester, the year later, was the missionary who sued on behalf of the tribes, right? Because the Indians couldn't bring suit. So they couldn't bring suit, they couldn't testify, they couldn't serve on a jury, and they couldn't attend public school or purchase alcohol. So all those rights, they were not granted even though they were citizens. So in 1928, again, you get two Pima Indians that were living on Gila River. They tried to go register to vote. Again, they were refused. And they said, hey, I'm a citizen under the Indian Citizenship Act, and they were still refused the ability to go vote. Court said that even though they were citizens, they remained Indians, and Indians were wards. And since they were wards, according to the Arizona Constitution, they could not vote, period. They said no person under guardianship was qualified to vote. So they used the insanity provision of the Arizona Constitution. So they said, that again, they added the great additional language. The man, for any reason, who is exempt from responsibility to the law for their acts cannot be trusted to manage his or her own property, or as a matter of common sense, be trusted to make laws for the government. So in 1940, Congress now passed the Nationality Act, which again gave citizenship to Indians who participated in World War II. Fifth time they were given citizenship. Harry Truman said, right, and he created this national committee to say, hey, what's the status of minorities? How are they being implemented these rights? And really the committee called out New Mexico and Arizona and said, hey, you got to grant the right to vote to Indians. So 1948, you get Mr. Miguel Trujillo, who is a Laguna. So he went to go register. He said he's an Indian not taxed, therefore he couldn't be eligible, even though he was a sergeant in the Marines and fought in World War II. So you see the picture of him in his uniform. So you also see New Mexico voters trying to go register after Truman's report. Then you get Arizona, who overturned Porter, and they said, we hold the term persons under guardianship no longer has application to the plaintiff. So interesting, in Montana, when we're talking about conquest and guardianship and again those provisions, so here you see there was a big budget cut on a congressional appropriations, and so they started paying out all the paychecks for the Bureau employees from the tribal accounts. They're like, hey, the tribes will pay for them, so the money they earn from their timber, cattle herds, other resources, they started paying the service for those who were, implementing the law to their detriment. They actually had to pay for that out of their own account. Also, they were giving out drought cattle, so they were buying them at $12 a head, giving them for free to anybody who needed relief, yet they were charging the Indians at $140 a head out of their accounts to receive these, drought cattle. Same goes to some of their cattle costs. They said they were giving cattle loans at 70% interest. And then the government still had management, so they said, well, you're still incompetent, so we get to manage your herd, and therefore you can't like have full say over the herd even though there was crazy costs. Actually, if you look at Fort Belknap's Constitution, when they were looking to ratify the IRA, it was actually they wanted more control over their tribal cattle herd, and they wanted the government out, which is why they rejected the IRA originally, which is interesting. So there was a proposal to repeal the liquor laws and also the prohibition on buying ammunition and selling clothing. So this is a report from the Montana Intertribal Policy Board. But here, in order to do that, they had to give up their ability to have local tribal courts, tribal police, and accept state criminal jurisdiction. So all the tribes disapproved of that. But you see part of the culmination of Public Law 280, which happened 3 years later. And then in the letter to Fort Belknap, so interesting enough, so Fort Belknap was the site of the Winters case. So Winters doctrine creates reserved water rights. So all tribal reserved water rights were won at Fort Belknap because they won a right to the Milk River as part of their inherent rights. So here the government was making them pay for their own water. They're like, hey, you got to pay for the use of your water. The Secretary of the Interior said, no, you can't do that. You can't charge them for their own resource. And the Bureau did it anyway, right? Under the idea of plenary power. So also, another interesting one, at Blackfeet they said you can't play stick game no more, you gotta go to bed after 6 o'clock, right? So no more gambling. So Maine, 1954, was the last state, or, well, you get Utah right after that. So first time some Indians were allowed to vote in Maine, 1954. You see Lucy casting a vote there for the first time. Then in Utah, again they were denied the right to vote. So Preston Allen, a Ute living on the Unitah Reservation, court said that the statute was not a denial of their right to vote on account of race, but because they was a resident of the reservation. Supreme Court said, sent it back, said, Utah, do it over, you can't do that anymore. Re-examine your ruling. The Utah legislature rescinded the statute. Indians were allowed to vote in 1957, says the last one. So then we get the 75 Commission that still says, well, there's still prohibitions on Indians being permitted to vote, really calling out Arizona and South Dakota. And then you see a lot of what they call the Indian Jim Crow laws, right? So again, the poll taxes, literacy test, English language test, voter intimidation, all were limiting tribal voters, even though they all had the ability to exercise the right to vote. They were still prohibited. So now you're seeing a bunch of challenges. So Montana had both Stapleton case, Western Native vote, B. Jacobson, and there's the push again to amend the Indian Voting Rights Act. So you see some of discrimination and intimidation in Indian voting that's occurring. So questions, comments, thoughts?
So wait, I'm going to pause you really quick so I can bring you the microphone and we can get you on our speaker. Also, these chairs are extremely hard to get out. I'm hoping you're not catching this on the camera. Okay.
Come over there.
I made it out. It's okay.
So thank you for the talk. That was really informative. I guess within the context of the 100th anniversary of the Citizenship Act, it feels like...
What are we celebrating?
Yeah, well, kind of, yeah. I mean, I know these things are always a process. There's not like this moment, this thing happens and going forward, everything's glorious. This is part of a long process. But given all of this, how do you frame the meaning or the importance of the Citizenship Act then? Because I don't know how I can.
Right, I mean, it's interesting, like, hey, there's these 5 attempts, like, continuously, it's like, hey, let's give citizenship, but even after the fact, we're not providing the rights and privileges associated with citizenship. And so I guess the takeaway, as we look at the importance of the act 100 years later, it's really looking to all those policies we talked about, and how do we go beyond this idea of diminished capacity, limited sovereignty, limited, you know, the whole idea of implicit divestiture, and, you know, and really call it for what it is, right? Rehnquist made it up in 1980 in Oliphant and said, hey, your sovereignty is diminished. And everybody's like, oh, okay. Like, well, no, it's not, right? There's no authority, there's no ability. And as everybody exercises their ability to work together and be sovereigns, you know, and build relationships, because tribes in the state and the counties and the feds all need to work together to address the future, and whether that's through agreements and otherwise, they need to work together and quit thinking about this this idea of conquest, the myth of conquest, and to move forward with the idea of how are we going to cooperate and govern.
Thank you. This is really informative. I had no idea. And so it seems like then there is a shift. Do I perceive correctly that there is a shift, that tribes are asserting their sovereignty much more proactively these days? And that's what it feels like when I listen to the news. But are you saying that in fact we're still stuck in this spot?
Well, both, right? So tribes are asserting their sovereignty to the extent they can, right? You still get a lot of these acts that have limitations. So a lot of the Bureau policies, the whole Title 25 of the U.S. Code, which is titled Indians, still has a lot of these antiquated prohibitions that limit the ability to really exercise your sovereignty, still provide, you know, oversight with the Bureau, how they're engaging in things. So like tribes are moving in that direction, they're implementing, you're starting to see more co-management agreements, co-stewardship agreements. But at the same time, you're seeing this pushback, which obviously why a number of states, and they're trying to like push back on the idea of what are these limitations on voting, right? Even the Indian Child Welfare Act, you get Brad Keene that was challenged. We finally got Montana Indian Child Welfare Act passed, and they put the sunset provision on it. So 2 years later, they're like, hey, you got to do it again. So now it's up again. And what we found was, like in Montana, most judges, a lot of state court judges weren't following the provisions of the federal act. And therefore, it was important. And their excuse was, well, we don't know how to fit this federal law with the state law. We don't know where it goes, so we're just going to follow state law. So we're like, great, let's put it into state law. Now you see where it goes and how it fits. But then even the legislature was limiting it because it passed with the sunset provision, so now it has to be reenacted this upcoming session. So again, even though you get these furtherances in sovereignty, you get at the same time the continuation of diminishment at the same time.
trying to understand the recent, and I say recent, based on what I've read in the news, between Lake County and the criminal justice system in the state versus what happens on the Salish Kootenai Reservation. I mean, it seems to me that the Lake County trying to push it to the governor may be the right attitude, but I guess I don't, listening to you and listening to the history of both all of these different federal and laws and court cases, I don't know how we're going to sort it all out, I guess.
Well, I mean, to me, the solution is give the tribe the money to do it, right?
Yeah.
Let the tribe tax all of Lake County. Everybody within their reservation, they'll be fine. They can do all the criminal jurisdictions they want, right? I mean, if some of your landowners would not want the tribe taxing those, but if they actually said, hey, this idea of diminishment, which is made up, isn't actually legal, there's no legal basis for it, like the tribe should have the ability to tax everybody within their homeland, then there is no dispute about who's exercising authority. And if they say the same divestiture that was made up in Oliphant that says, hey, tribe gets criminal jurisdiction over non-members, great, they can deal with it, right? So it's these effects of these policies, and Public Law 280 was, again, when we've seen in the 50s with the ability for the feds said, hey, we're going to acquire this authority with regard to major felonies under the Major Crimes Act, right? Because you had ex parte Crow Dog, Chief Crow Dog killed Chief Spotted Tail, whole bunch of backstory on why it happened. But essentially, they dealt with it according to tribal law, and it was done, right? Supreme Court said tribal law applies to Indians in Indian country, you gotta let them out of jail. Congress freaked out and said, hey, we can't have Indians determine how they deal with murderers. So they said, we have that jurisdiction. Then in PL 280, they're like, we're gonna give it to the states. We don't want it anymore in these certain jurisdictions, right? So CSKT's the only PL 280 tribe. All the other tribes rejected it, said, no, we don't want that, right? So now, 70 some years later, you get this dispute about states saying, hey, I don't want it anymore, right? And there's no provision. Fed's like, well, we don't want it back. No take backs. You can't give it back, right? And because they're not paying for it. Because those federal dollars are then cut off. So even the tribe, with regard to law enforcement services, even their self-determination contracts is limited. So they get some money for policing, justice, for like conservation, but not for police. And now it's a fight over resources. And so, like I said, you want a quick fix, let the tribes tax all Lake County. It'll be all right. They can fund it.
I've never been able to square the sovereign tribal nations with the United States. And I know there's a lot of issues there, but how would you respond to why should somebody living on the reservation vote in a United States election if there's two different countries involved? I mean, we don't let people from France vote in our elections. So I know I don't have it right, but I think you get my gist.
Right. So the idea is that they're tri-sovereigns, though, right? That's actually what the Citizenship did. And they're like, hey, we'll open up all your land, and in return, you can become a citizen, right? So they're a tribal citizen, state citizen, U.S. citizen, right? You do let somebody vote who's got dual citizenship with Canada or France, if they have dual citizenship, they can still vote, they can still run for office. So just having multiple citizenships doesn't prohibit them from actually exercising those privileges in that jurisdiction of which they have a citizen of. So that's the easiest explanation. Like, we see it all over the place. Shouldn't be a difficult concept with regard to Indian country.
I feel like the story hasn't been finished as far as citizenship of Indians in your presentation. Was it eventually granted with the Voting Rights Acts of the 60s, and now they have full voting rights citizenship among the Indian nations?
No, well, allegedly, right? So that's where you're seeing even in Montana, like, which is why we had the Western Native voice cases, because it was being limited, right? It was artificially being restricted. Same thing in Arizona. So the idea that, hey, you can't collect a bunch of ballots to go drop off because the drop-off site's 100 miles away, like, that's restricting Indians from actually voting. If they don't have gas money or a car, like, someone can't, like, bats them up. So
Well, those would be de facto restrictions as opposed to de jure.
So ideally, everybody has the provisions, everybody has the ability, but de facto, it's still not playing out. So the same in North Dakota when they had just a recent case with, hey, we don't have, a lot of Indian country doesn't have their, what do they call it, their rural route numbers, or, so Google was creating like the geospatial areas, like, hey, you can use your pin site on your phone. Everybody's got a phone, right? Everybody can be like, here's my location. Boom, that's what we're using for address. There was fight over allowing that as part of your address and your PIN because the services haven't been provided. And to me, I think that's actually more of a rural issue than just the Indian country, non-Indian country issue. Like, you're seeing some of that effects in rural America generally too, the same prohibitions and limitations.
Are there tribes among all of the tribes that are doing better at this moving on? And the second question, in what areas are they most successful?
Yeah, there's a lot of tribes that are doing really well, and part of it is the ability to build capacity, right? If they have the ability to build capacity to take over the programs, infrastructure to effectively govern, that's the key. So that they have the resources available to build the ability to take over, whether that's in child welfare, whether that's in natural resource management, whether that's in law enforcement, whatever it is, it's building the capacity to govern and be effective at it. And having the ability to really be self-determinative. So when we think of sovereignty as self-determination, to create the program in their unique way, not with limitations that the feds or the states put on what those limitations are. So when you take the hurdles or the obstacles out of the way, tribes are super successful at governing. It's just dealing with all the barriers and the obstacles, and we've seen all these legislation policies in place. So even again, when we think about child welfare, hey, we have ICWA, great. Here's a national act to implement Indian child welfare, it should be amazing. But are states following it? Some aren't. Where's the funding come from? Title 4E of the Social Security Act, which doesn't say anything about ICWA. And so states are using their funding, right? And until they fix Title 4 and how that's implemented, and they'll let tribes have direct access, which they're starting to in child support and other programs, like they get the ability to be self-governing. So it's really fixing those hurdles that are blocking tribes from really being sovereign.
In what areas? Are there areas, I guess, just
All of them.
child welfare,
All
resource
of them,
management?
right? You still get all these policies and that are starting to change slowly, right? But then even with self-governance, with stability, like, hey, tribe, you can enter a self-governance compact, really effective. But typically they're like, we're gonna bundle all your services and you're only gonna get probably 60% of the cost that would actually, if you like piecemeal them out, right? So again, it's still limited funding. Like if they maximized what was owed to them pursuant to the treaties and agreements and those trust responsibility, they could be super successful at governing.
Yeah, I'd just like to kind of bring, and I don't know if you're aware of them or not, but anyway, in my mind, two fairly successful areas where authority's been turned over to the tribe. The tribal colleges are very successful. Like you say though, one of the key things is the federal government helps fund them a little bit. And tribal voc rehab programs, again, they do have some specific tribal funding that they have available, but they're run by the tribe and they're very successful programs. I think they serve the people of that reservation and much better. So I'm not sure if you've had much dealings with them, but they seem to be real successful.
No, I agree.
The subject's pretty overwhelming and quite a bit of tragedy involved. And I'm just, what you said, the 1966 tribal Indian law was a kind of an authority of a sort. Is there current reading, or is there an update, or is there good reading that we can go to?
Yeah, so
educated now?
even if you look at the Cohen's Handbook of Federal Indian Law, there's, I think the last print version was 2014, but it's online, you can still get like current, but it's obviously been updated to dispel some of those early myths. But yeah, so I think that if you look at PVAR's got the Right of Indians and Tribes, which is a good resource overview. Judge Canby from the Ninth Circuit did Indian Law in a Nutshell, which is a good overview.
Great, so I think that's a great place to end it. So I hope you guys all do some further investigating, and thank you so much. That was extremely informative.